home are welcome to our Senior Concerns Seminar Series. This one is presented hybrid, so we have some of you here in person with us and others that are watching from home through this new fancy camera that we have. So our speaker will try to stay near the camera and we're going to speak up so everybody can hear us. That means we also have people at home that might type in questions as well. So those of you at home hopefully can hear me well. If not, you have the ability to type into your Q&A box on your screen any questions or comments. So you can let us know if you ever can't hear us or see the screen. But otherwise, we will go ahead and get excited about this topic today, which is estate planning helping your helpers. And having just gone through this, remember, it is very complicated, and sometimes things that we are clear and easy and in place are not as clear and easy and in place as we would like. So I think this topic is so important, and I've heard it so many times in my, yet I've always learned something new because you have a different perspective, I think, every time. So I'm really excited about this today, and we have with us today Heather Hunt Scott, who is a board member here at Senior Concerns and an estate planning attorney. Heather advises clients regarding comprehensive estate plans, including revocable living trust, irrevocable trust, estate tax planning, special needs planning, and other related planning. Death administration of an estate. She assists clients with probate and other court proceedings, trust administration, death, tax filings, and related issues. Any of those words didn't make sense to you, then you're in the a lot to talk about today. So thank you so much for being with us today, Heather.
Thank you, Martha. It is my pleasure and actually my honor and privilege to be here today for having me. I know that earlier today the therapy horses were here, so I'm sorry I'm not the most fun that's been had here today, but I'll try and come to a close second, I guess. So we're here today to talk about helping your helpers succeed. So an estate plan. So I'll show you what we're going to talk about today. So we're going to cover the components of an estate plan. What is an estate plan? It's likely that many of you have estate plan. I will tell you in California that if you have done no estate planning, the state of California has done your estate plan for you. So everyone does have a plan, they just might not know it. We're going to talk about the roles that people can have and the rules that they're going to follow. And then kind of get into how we can help them succeed. Okay, so your estate plan, everybody's different. Not everybody has the same estate plan. It might have a trust. It might not. Not everybody needs a trust. It's okay if you don't have one. You might need one if you don't have one. You can always talk to somebody and see if you do. But maybe you just have a will. That's okay. That's maybe all you need. Powers of attorney. So these documents will, go into a little bit, but you probably, if you have an estate plan, you might see a power of attorney in there. Advance. Documents. So things like deeds and stock certificates. Okay. So all of these documents, maybe not the assignment document, the trust, the will, the powers of attorney, the advanced health directives, all these documents do is name people who can do things for you, what they can do. That is the sole function of all of these documents. They kick in, right? They take effect at different parts of our life, or maybe with regard to different assets. Okay. A trust and a will are very similar. They name who can basically manage your assets, right? And under what circumstances they can do it. A will says who can manage your assets after you've died. Okay. And it outlines what they have to do with your assets. Do they have to give your assets in equal shares to your children? Do they have to sell your home and give 40% of the proceeds to your brother and 60% to your sister because you like her more? It doesn't matter. It just outlines what they can and what they have to do. A trust is like a will, but it exists both while you're living and when you pass it. While you're living, it tells the world essentially who can act on your behalf if you become incapacitated and what they can and can't do. When you pass away, it directs what happens to your house. I realize not everybody has a trust. If you have a trust, the only thing that your trustee can do is manage the assets that are in the trust. If you have a house and a trust, it's likely that your house is in your trust. And if you become incapacitated, your trustee will manage your house. They'll pay the gardener, they'll pay your property tax, they'll fight with the HOA, whatever it is, to do that, okay? You might also have assets that are not in your trust. That's okay. Not every asset goes into a trust. Powers of attorney will help your helpers take action on your behalf if you become incapacitated for assets in your name. Retirement pension, a lot of these things are never put into a trust while you're living. There are federal rules that prohibit you from putting your IRA, into a trust while you're alive. So I'm going. What happens if you become incapacitated? Does everybody know what an RM, if you don't know, is a required minimum distribution? So retirement accounts, when you hit a certain age or something happens, your required minimum distributions will kick in. The IRS says you have to take a certain amount out each year and pay the tax on it. Maybe not for a Roth IRA, regular IRA, you have to take some out each year. And there are tables that tell you how much you have to take out each year. If you become incapacitated, do this. Your agent under your power of attorney can do this for you. They can call Schwab and say, please initiate the required minimum distribution for Jane Q taxpayer. And Schwab will say, I don't know who you are. Why are you calling me? And you say, oh, I have a power of attorney. I'm your helper under the power of attorney to say that this is what you have to do. And they go, okay, send us a copy. Here you go. Thank you so much. We'll go ahead and do that for you. And so these documents all say who can act on your behalf, and they prove that you have the authority if you are the helper. Okay, so if you go to the bank, they're going to look at an account. They may not be. They're going to say, okay, we need a copy of the trust. We need a power of attorney. We need this, we need that. You're going to see if the estate plan has that document and names you, and you're going to go in and you're going to help this person. If you are the person whose account it is, you're going to be thoughtful about who you are going to nominate, right? Many parents nominate their children, their spouse, a cousin. I named my cousin in one of these roles. Maybe name the, brother who has a lot of family debts and a couple of bankruptcies under their belt. Maybe that's the type of person who will maybe not do the best with your money that you want. Okay. These are sort of the components of an estate plan. We also have assignment documents. These are the documents that say what's at issue, right? So if we have a trust, we assign our assets to the trust. We sign a deed saying my deed or my house is now in my trust. My stock for my S corporation or my, I have actual stock certificates for Apple because I bought them in 1983. I didn't, but you might. You can sign those and say, this is now a trust asset so that your trustee can act on your behalf. We have things like beneficiary designations. If you have a retirement account, if you have life insurance, pensions, many of these things will allow you to name a beneficiary. Beneficiary, when you pass away, they just collect the assets. They provide proof, they provide a death certificate, they fill out some forms, they get these assets, okay? Maybe you need to change that. Heaven forbid, you become incapacitated, one of your children also passes away. Maybe the beneficiary designation on an asset needs to be changed to take that child. This does happen. It's unfortunate, but it's the reality of what we're going to do here. Your helper, right, your power of attorney can help with that. They can make sure that assets don't go through probate. Okay, so those are components of the estate plan. All right, so the roles and the rules. There are basically two roles and 85 different documents that can delineate these roles. So right, trust wills, powers of attorney, these are all just documents that outline the rules to follow and the roles that people can have. Okay, so who is subject to the rules? A trustee is subject to the rules of the trust. An executor is subject to the rules of the will. Agent, power of attorney. These are just people who manage financial decisions. All the same thing. It's a dollar sign. There's a dollar sign involved. A trustee, executor, an agent of your power of attorney. It's typically the same person, right? It's the person who knows how to balance a checkbook, who can talk to financial advisors, who can do these things for you. Okay. In your advanced health directive, it's also called an agent. This person never has to see any of your bank accounts or any of your dollars. They're just making decisions about your health care if you become incapacitated. Leading to a course of medicine, a surgery, you know, any number of things that can come up in a medical setting. These people will be making these decisions. Do the trustees and the executors and the agents, do they need to have a CPA or a financial advisor's level of expertise? No, they need to have a CPA or a financial advisor's phone number. Okay, all they need to know who to call to help them. Okay, similarly, under your advanced health directive,
Is it okay to ask a question?
Of course, yes.
To the end.
yeah, no, you
Maybe you should repeat it so everybody can hear it after. So this question worries me because last night my husband says to me, if I go to jail, can you then solely responsible for our trust and making decisions around that? And he's watching some show on Netflix and it's happened and something.
So, Andrea, the Director of Senior Concerns question. If my husband goes to jail, would she be solely responsible for making decisions regarding their trust? My answer is, I don't know what your trust says. So the trust is a rule book, right? And it says the conditions under which a person can act. My trusts say that if a trustee is unable or unwilling to act, then we go to the next step. So maybe Andrea's trust said, you know, Andrea's, what's his name? Peter. Andrea and Peter are co-trustees. If either of Andrea or Peter is unable or unwilling to act, the other of them will act as sole trustee. Very common, very common. How do we define unable or unwilling? Well, unwilling is pretty clear. I don't want to. Unable, there's no, depending on what your husband has been convicted of or the alleged crime, there may not be any restriction on him continuing to act as trustee. So the restrictions I see in that situation are a little bit more pragmatic. it is sometimes difficult to get documents notarized in jail. I do believe they have, so I'm also a notary, and there are actually like special notaries for jails and prisons, so it may be that it can only be done on like Wednesdays from 3 to 5 or something, so that might, and again, I didn't actually say this at the beginning, none of this is legal advice. So seek the counsel of a qualified estate planning attorney. But were someone to come to me with this situation, I would advise that your husband should probably resign and allow you to continue as sole trustee. If for some reason he, is liberated from his bounds or binds, he can come back in. There are typically ways in a document for someone to be out and then back in. I would say just logistically, pragmatically speaking, it's easier if he's just not involved. And you can say that to him. It's probably easier if you don't.
I'll go to jail.
He's just watching too much.
I have a question. So how do we know if you're incapacitated? How do we know if you can't do this? Or if you don't want, there are different ways. If you don't feel like doing this, if you don't feel like doing your banking, you don't want to, you can accomplish that goal. You can put in your trust, or you can resign as trustee of your trust. You can create a power of attorney that's immediate, that gives your helper immediate control. They can go to the bank. Sometimes I will tell people, like, let's have the children start earning their keep around here. Get them to do it for you. Now, people don't, my daughter would just have, she's 14. Sephora would never see a windfall like if she had control of it. But like my parents are 85 and 83. And they would probably cause some serious physical harm to me if I suggested that they give up any of their, control or anything. I repeatedly tell them I want them to move to University Village, actually. And I'm almost going to be disinherited at some point for suggesting that they do anything. My mom has like a terrible knee, and she's fallen twice, and everything over there is so smooth that I'm like, let's just go. Let's just check it out. But they don't want it. But so it depends. There's a lot going on there, and there's a lot to unpack of, are you ready to let someone else help you? If you're not, then just leave things as they are. And if something happens where you're actually mentally incapacitated, car accident, coma, legitimately we cannot ask you a question, well, then they can help you, and you want that. But most people, I think, if they're able to do it, they still want to do it. And if someone has, sort of diminishing capacity where they are, memory issues, or sort of, maybe creeping into Alzheimer's, dementia, or things like that. You just touch base with your attorney. There are things that you can do, and you can kind of think that people don't usually start, wake up one day and are perfectly wonderful, and then, half an hour later lose all capacity, other than like in a car accident. So that, people can still control things while they're mostly able to. Sometimes people have bad days, but the majority of the time are good days. I wouldn't say that's, immediate cause for having someone removed. Okay, but so these documents outline the rules. I don't know what your rules are. I don't know what you've set up. Okay, some people have trusts with a spouse. Maybe someone in this room's spouse has passed away, and now you have two trusts that came from your one joint trust. Very common also. The decedent's share, the survivor's share. Survivor can go to Vegas and bet it all on black, but the decedent's share stays in trust for them. They can't really do anything but live off of it. And this is usually to ensure that, you know, if I pass away, I don't necessarily want my surviving spouse to remarry and give it all to their new spouse. I want something to go to my children, right? That's a very common scenario.
Is that considered the AB?
Yeah. That's an AB trust structure.
And are those still common?
So yes and no. So back in like 2000, 2004, the estate tax exemption was between like 600,000 and $1 million, $2 million. In the greater Los Angeles area, Ventura County, Santa Barbara, anywhere in California, basically, all you have to do is own like a house and a retirement account, and you're over that limit, right? So at the time back then, it was very common to split these up because the B trust, the decedent share, that would not be subject to estate tax when the survivor passed away ever again. Those assets are no longer subject to estate. Okay. Getting into the weeds a little bit, but now the estate tax exemption is currently 13.99 million, and married couples get to share. So we're at almost $28 million. Next year through the OB, it's going up to 15 million and will continue to rise. Most people are not in a 15 or $30 million position for this to be an issue. But some people want the protection. If you're 35 and you know, setting up a trust with your spouse, if you have get involved with some, I mean, it happens, right? And you wouldn't necessarily, maybe some people would, but you wouldn't necessarily want your spouse to go on for 70 more years and meet somebody nice, right? I mean, mine shouldn't do that. Should mourn me every day, but no. For share for your children or your beneficiary. Maybe you don't have children, but you have a charity that's very important to you and you want them to get it. So that would be a common reason to continue to do that. And I do that from time to time. And you know, sometimes I'll in the meeting, I'll get a certain sense that, oh, we should definitely do this. And you know, I'll be surprised that the people make it to the next state planning meeting. So you know, but so yeah, so all right, so these are the people who are going to be subject to these rules. What happens if they don't follow my rules? We're in a lawsuit, right? Not necessarily, right? Sometimes things happen, laws change. There's a no foul sort of energy to everyone. You set up and they don't. So you set up the AB trust and the survivor gets remarried, has another child, and just pulls everything out of that B trust. They can get sued, and they can get sued for every penny that was in that trust. The spouse gets to live off of those assets. The remainder beneficiaries, the people who get the assets when the spouse dies, they typically have what we call standing to request information about this trust. I want to know what's in there. I want to know what you've done with it. I want all the information. Most of the time, people aren't going to ask. There are many reasons I could get into about that, but you know, so let's say my husband and I have an AB trust. He passes away, and his share goes to our daughter. Right? I get remarried. I then pull everything out. My daughter can sue me. She can say, "You breached your duty as a trustee. You didn't follow the rules. I'm suing you." So not only will the assets go back in that trust, I may have to pay penalties. I may have to pay interest on that. I may not get to use them after that. I will have to, you know, a third party might become the trustee. the court might require some independent, a bank or something, and they're gonna charge a lot of money to do that. So we're gonna dwindle some, so it's not good. Okay, so that's a trust. Hard not to follow the rules because a will always goes to probate if you don't have a trust, but not always. You may have a will and you may also never have any assets go through probate. Talk about. But yes,
How do you avoid probate? That's what I'm gonna.
so it depends. If you have a trust, the assets in the trust typically avoid probate. Some assets don't need to have a trust. Let's say you rent an apartment and you have an individual retirement, but only assets. You can name a beneficiary on your retirement account. So my cousin Kristen is my beneficiary of my retirement account. If she's not living, it'll go to her children. You can list that on a beneficiary list. That won't go through probate. And I have a life insurance policy. My beneficiary is my trust, but if I didn't have it, my husband would be the beneficiary.
What about a house?
So the house is in California. It's typically a good idea if you have a house, if you own real estate, to have a trust. There's a deed that you can use that names a beneficiary. They are not the greatest vehicle for this because you can only name people. You can't name classes of people. So for instance, if I name my brother as the beneficiary for my house on this deed, I can't say if he's not living to his children would.
Then what happens if it is a
Probate. So a trust can help you with that. So a trust, you can say like, okay, my brother gets my house. If my brother's not living, to his children, if they're not living, to their children, if they're not living, wounded warriors, you can get 85 people in line for that property.
Mr. and Mrs. If you want to.
You can do multiple people. You can do, Sarah and Jeff, but or the survivor. If they're both gone, what happens? Yes, ma'am.
For the people that probate
Is the process in California. So I will just take a step back. The word probate law is everything having to do with trusts, wills, probate, guardianship, conservatorship, anything where you control something for someone else. You are most likely going to be in probate law and in probate court if you're. Probate actually comes from a word meaning to prove. So we're proving up that we have authority. We're proving up that this is what the decedent wants. Okay, so probate is where we go to the court and we say, this person died and had assets over a certain amount. They had assets in their name. We need to get them to the people they're supposed to go to. It says, okay, here's your order and whatever. So the way it works is that if you just pass away in California and you don't do anything with any of your assets, the probate code outlines who is allowed to ask for permission to control the assets, who gets to be in charge, right? And then probate code says what happens. What happens to the assets? If you have a will, the probate court will look at who you've asked to be in charge. So I nominate Andrea. Andrea can't do it. I nominate Mark. Mark petitions the court, and the court is going to say, "Where's Andrew?" Well, Andrea might file a document because I don't want it. They're not going to make her do it. So Martha gets appointed the executor of my will, and she then has to follow the rules outlined in my will. It's almost like you're a plant in the audience. Yeah. Based on a percentage of the estate. So the probate code says, here's how much you get paid, executor and attorney. okay, it's 4,000 or 4% of the first $100,000 at issue. 3% of the next $100,000, 2% of the next $800,000, 1% of the next, I believe, $1,000,000, and then 0.5% up to 10 million, or maybe 1% up to 10 million, 0.5% up to 100,000. Both the administrator and the attorney. So it's that times 2. So on a $1 million estate, the fees are $23,000 to the attorney, $23,000 to the executor, and it's the gross value, not the net.
So you figure out the bank.
Yeah, if you have $1 million house with a $900,000 mortgage, my fees are based off the $1 million value, not the $100,000. Actually, so low. Also, just pay an attorney, you get a trust. So and there are things you can do. I have people come in and I say to them, you don't need a trust. Just name beneficiaries. Get some powers of attorney in place. You may not need all of this complication, but you might want to. I mean, it also takes, it doesn't matter, Ventura County, LA County, it's going to be 1.5 years.
In probate.
Yeah.
There's a standards.
No, beneficiary designation typically will take, depending on the institution. I mean, some might know that someone's died before you do. Others, once you provide them with the death certificate, it's typically they want 40 days to have elapsed between the passing and the beginning of election, right? So, you know, if I'm a renter and I have a retirement account and I name my daughter as beneficiary, whoever is backup, that might be enough, because heaven forbid your daughter pass away and change the beneficiary designation. I can make sure it's updated. So there's, you don't necessarily need to, but that's a rule that you have created with Schwab, right? What happens if Schwab doesn't get it? Lawsuit. They can sue Schwab. You can, I mean, granted, Schwab's probably not gonna, what skin do they have in the game? They wanna do everything right. But they're going to make sure that they have the right to do this. They are going to ask for an original death certificate. They're going to ask for maybe a copy of your ID if you're the right person. They're going to ask for information that you'll have to provide. So the reason, and for probate, the reason we go through probate is because, let's say I have a client right now, there's a $600,000 account at Chase. She goes in and Chase says, I don't know you. I need some proof that you are allowed to do this. Go to court, bring me a court order. That's a probate order. That's just letters of administration, because what do banks have to rely on? If all you had to do was walk in and say that's mine, many of you would be very poor right now, right? It'd be very easy to just walk in and say, no, she's my mom, right? All I have to do is find someone who looks kind of like me. You fit the bill, let's go. She's getting me out, there's nothing stopping anyone. It's the state of California and it's the court's way of saying we're gonna maybe supervise this and make sure that the money goes to who it's supposed to go to. Bank's gonna require some proof. They're gonna say, provide me with letters of administration or letters testamentary. Only get by going into court and opening.
I'll start going everything in do any. How fast and how can we get the money? And they said, I opened it, and then they said all they have to do is bring in the death certificate.
Yes, typically. So the question for the viewers at home is, Wells Fargo indicated that all they would require is a death certificate if the account's listed a beneficiary on the account and their ID. And that might be sufficient. It's gonna vary by institution. So and they might change their policy tomorrow. So you know, B of A, there's no good. I wish that I could say, no, go here, like they are all this. Yeah. Yeah, so we can go to court, we can make sure the rules are being followed. And that's what a good trust does, that's what a good power of attorney does, it outlines what you can do, right? It doesn't necessarily outline everything. So we're gonna show you how to, or I'm gonna show you, or how to help your helper, right? So. Estate plan. Where are they? What assets do you have? They will need to know this. What banks should they be going to? Do you have? Who are your beneficiaries? They might need to know all of this. So we want to strike a balance between being careful and private with our information, right? We're not going to hand out a bunch of, you know, bank account numbers and social security numbers or anything like that. And we do need someone to know what to do if we pass away or if we become incapacitated. Where are my documents? Okay, my trust, my trusts do not list actual assets. They don't say Chase account 2347938. I don't want someone getting a hold of that. And to be honest, some people come in and I look at their trust and it's got a Lehman Brothers account and a Washington Mutual account listed, and I'm like, these are all gone. I don't know what assets you have anymore because none of these things exist. So where are your documents? Maybe you keep them in a safe deposit box. Maybe you have a safe. Maybe you keep them in a closet. The vast majority of people, I think, actually just sort of keep them in a closet, a drawer in their desk. They're not necessarily locked up. They might not need to be. My documents don't have personal info. They don't have my account numbers. They don't have my social security number in them. So it might be okay to tell your person, your trustee, your agent, whoever it is, they're in the upstairs office left drawer. They'll find them. You can give them your attorney's business card and say, my attorney has a copy. Here's their information. You can documents to people. I'm a little reticent to suggest that because falling outs happen. Maybe one of your children marries someone that you hate, and so now you're favoring the other child and you don't want to name them in your documents, but this one has the old documents and that's going to cause a fight. So just be thoughtful about who you email your documents to, who you share them with. They don't necessarily need to have them. Maybe your health directive is kind of one of the more important documents to circulate. You know, my parents, my mom had me email everyone with a copy of her health directive. More because my parents disagree on whether or not to keep someone alive. And she very clearly has stated, don't let dad, you know, make this decision, because he would keep her alive forever and ever. And she's, you know, more of a don't do anything, I'd rather just go. He doesn't know what anything is, so he keep her alive. But yeah, so like, don't go giving people information that with your social and your bank account numbers or anything, but like, you know, give them some guidance. Yeah, so you can change these documents, just be careful. I have a client actually who has 11 children, has changed his estate plan probably 3 times a year for the past 15 years. Because he is favoring one child and mad at another one, and he'll bump someone up 0.5% and lower someone. So like, you know, you don't want to necessarily show everyone like, I can mark by the date you signed this when I was dating that guy you didn't like, you know. Okay, so what assets are we talking about? Real estate. So your agent, your trustee, they're going to have to pay your bills. They're going to have to pay the homeowners association, property taxes. your gardener. Do you have cable? Do you have all of these things that need to be kept going? If you pass away, some of those things can go. Nobody cares if you have cable or if you've passed away. But property tax should be paid and the HOA fees, a mortgage. Want to keep those payments going so there's no foreclosure, so there's no action. Yeah, your gardener, your cleaning lady, all of these people, they still need to get paid or be informed that, you know, maybe their services are no longer needed. And that's hard to tell someone, but they'll understand it's probably not their first time dealing with this. You know, maybe you have a newspaper delivered. That still happens. And you want to call and say, like, you know, please cancel the subscription. You want to have mail redirected. Locks should potentially be changed. I recommend, you know, when people come to me and tell me that someone has passed away, depending on the circumstances, I will recommend a lot of times for them to change the locks on their house. You don't want someone who had a key at some point, a maid from 10 years ago, you know, hearing that someone's passed away and going in. I don't, you know, like turn this into a Hercule Poirot thing and like the maid did it or anything, but you know, you don't know. Okay, so investment accounts. Do they have a Merrill Lynch account? Do you have, you know, you don't need to give account numbers, but you can give a breakdown of what you have. I'll make a list. I have these 3 real properties. I have a Merrill Lynch account. I have Schwab, whatever it is, you know. Do decisions need to be made? RMDs. Do we need to take an RMD? Did I don't know, sometimes a stock will tank. Maybe they need to tell your financial advisor to get me out of that and get into something else, right? So maybe they need to make decisions. So they should know, okay, I should touch base with the financial advisor or the bank or something.
Question on that one.
Yeah.
I thought you were focused right now on trusts. And so investments should be in the name of the trust or just noted, or how do you handle that?
It depends. You can absolutely put an investment account in the trust. And I think personally, I think it's easier to have as many things in a trust that you can have. Sometimes people elect to do like a beneficiary designation. Some institutions won't let you. So it will depend on the circumstance. I prefer to see an investment account in a trust if possible.
That's the one I would have to approve it.
If it's an account that does not have a beneficiary designated on it, and you pass away, it's titled in your name. So there's Heather Scott, right? And then there's Heather Scott, trustee of the Heather Scott Trust. Those are 2 different people. I consider it's a person, but it's 2 different people. And so if I pass away and it just says Heather Scott, there's no beneficiary designation, it will be subject to probate. If I put it in my trust, I still control everything. It's just in my trust. And I personally like to see it.
But if you pass away and it's not, there's no beneficiary, and it's in your trust, then it's gonna go to probate.
If it's in your trust, it will not go through probate.
I thought you said if it's in the trust. The things in the trust.
No, the things in the trust do not go through probate. That's why we like trusts.
So what goes to probate?
Something, if it's just in your name, it's not in a trust and it doesn't have a beneficiary designation.
Oh,
Yeah.
I thought if it was in the trust.
No. Sorry, and I apologize if I misspoke, but no. Assets in your trust should not go through probate. That's almost the whole point of the trust, is to avoid probate. Yeah.
And Lil, you've talked about the trustee should step up and, you know, take care of the property, pay the homeowner's insurance, pay the workers. If they, through which account should they be paying those things? Is it a good idea for someone to set up ahead of time a bank account where their trustee, maybe it's a child, maybe it's their brother or something like that, is also on the account, and then they don't have to jump through the hoops of
I'm incapacitated, so now you need to take over. It's easier for that person who can act but they don't have to sort of wait that time period to prove that someone's incapacitated.
So
Suggest having a bank account that,
not necessarily.
Okay.
And I know where you're going with this. So the question is, should someone have a joint account with their agent, trustee, helper, so that if something happens to them, they have immediate access to funds to pay for whatever is necessary? So it will depend. That's very, very circumstance dependent on what I would recommend to somebody. Frequently people come to me and they're, you know, in their 60s, not really looking at all like they're going to be incapacitated for any reason. So it doesn't necessarily make sense for them to have a joint account with somebody. A joint account can always be used by both account holders free. So if you put $20,000 into an account for just in case something happens to me, you'll have immediate access. We'd want you to be very thoughtful about who this is held with. It's frequently done with a child so that the child can manage the assets. And I'm not saying this is a bad idea. I'm just saying there are circumstances that would direct me to say no, some that would make me say yes. If you're 60, your kids often are, you know, in their 30s doing their own thing. You're not looking any behind like they're going to lose capacity. It may not make sense. It, you know, it just may not be the right time. But it's not a bad idea. You can also, it's not that hard to gain access over a trust account. Really, all you need is proof that the person either can't manage the assets themselves. That can typically be turned around within a week. And there's nothing like the property tax, like they're going to be fine if they don't get paid for a week. You know what I mean? HOA, if you call and say, hey, listen, here's what's going on. We just need a few days or a week or something. None of these is such a huge emergency that I would say that potentially jeopardizing some funds is worth it. That said, you can, and I know many of my clients do, and that's A-okay with me. That's your choice. That's fine. It depends also on the trustworthiness of your other person. You know, one of my brothers would be great. One not so much. Yes.
I recently did a POD on bank.
Yeah. So another option actually. So she put a POD, which is a pay on death designation, on an account, just so her person could get access to funds when she passed away, so that they would be able to manage all of this, all of the boring administration of paying taxes and, you know, bills and things like that. There can be some delay. Typically, you do need a death certificate. Those can take 3 to 6 weeks. So the bottom line here is there's nothing that's going to be this like perfect, total, immediate, wonderful solution. This is the part of this is what we call trust administration. And the administration part is key. It sounds like a boring, tedious thing. It is. And it's going to take time. It's going to take homework and going here and getting this and sending it there and having someone overlook your email and call them and say, did you get my email? I mean, there's going to be just a lot of that. This is not an honor. This is a burden. But yeah, no. I joke, but it is something that it'll take time. And if there's an emergent situation, if you're in an emergency, first of all, doctors are going to just do what they're going to do. If there's some sort of thing and they don't have someone, that they're going to revive you. They're going to do whatever their hospital policy says to do. If you can get there with the health directive, great. A facility, if you need to pay for someone in like a facility or something after they've been in the hospital, or if you need to pay the hospital. If it takes you 2 days to get access to the account, they're not going to hold in the hospital. And, you know, they're gonna call you every half hour. But they're going to kind of let it go. Is it, are we, so it's a little bit of like, yes, these things are important. I get a bill, I pay my bill. And so I know it's sort of uncomfortable to sit with the idea that a bill might come in and it might not get paid for 10 days. It might not get paid for 60 days. That's okay. Most of the institutions that you're working with, if you have a credit card or something, like if you call and say, I have hospital records, this person was at, we'll take the fees off. Okay. Yeah, you could put things on auto pay, your water and power, your trash pickup and things like that. Those can typically go on auto pay. Thank you. Yeah, there was a suggestion to put things on auto pay, which is a good suggestion. But yeah, it's okay if things don't get paid. You're more important. Like, there may be bigger things to deal with, and your people might just be sad. They may drag their feet because they are very upset that they've lost you. So, yeah.
Only about 1 minute, however. Should be in trust? Was there anything that should be in the trust? And the things are in the trust, does it have to be a formal agreement written? This bank account is in the name of the trust, or can you just say?
Okay, so the question is, what should go into a trust, what not go into a trust, and does something need to be formalized for something to be in a trust? Answer is typically, it's going to depend on the asset and your personal circumstance. So I will just tell you, I own a house, I have some retirement accounts, some investment accounts, I have S corporation, and I'm in a partnership, a business partnership. So my house, I think a house typically, yes, it should go into a trust. Some people hold their assets in joint tenancy, their house in joint tenancy with someone. If it can go in the trust, I recommend it does. Sometimes there are reasons it wouldn't, and it can stay. The survivor will then just own the thing. Investment accounts, yes, typically they go in a trust. Business interests can go into a trust. CDs, savings account, money market, all of your sort of after tax accounts go into a trust typically. Your retirement accounts cannot go into the trust. There needs to be an identifiable sort of person with a lifespan and a birth date to have a retirement account. You can name the trust as a beneficiary. Probably not the best idea. That's something you should talk to an attorney about before you go and do. But it's they won't let you put a retirement account in the trust. The bank will go, we can't do that. But so how do these things get in the trust? For the property, you do a deed. For your investment accounts, you will call the bank. They will have you fill out a form. They might ask for a copy of the trust or certain pages from the trust. You just give them that, and you'll start getting your bank statements that say, Heather Scott T and have words that look like trust in there somewhere and a date that's that. Oh, that's the date I signed the trust. So that it's in the trust. But it really depends, and your attorney should go through your assets with you and tell you. That's part of what we do. I think they'd be remiss in not going through your specific list. I always ask, give me a list of things. I don't need your account numbers, but I do need to know what type of thing you have so I can tell you, okay, here's what you need to put in the trust. I do some of these things. Excuse me. I will do stocks, for corporations, I'll do their stock certificates. I will do an assignment of LLC interest. If you own an LLC, I will do a deed. I can't go to your bank. Guess what they're going to say? I don't know you. who are you and why are you talking about Amanda's account, right? They will not know who I am and they shouldn't give me any. I don't have any. So they should talk to you about each one. Yes.
If you own something with somebody else, so-and-so or so-and-so or so-and-so and so-and-so, but you don't want them to get your hat moved up. Can you leave your hat to someone else?
Depends entirely on how it's titled. There are various ways of titling things. You can have, so for real property, you can have a joint tenancy, you can have a tenancy in common, you can have a life estate. So there are different ways. It would depend on the specific asset. Bank accounts are typically jointly owned and it's just free for all. So it'll depend.
If I could share, we have a few questions online,
Yes.
but I know we're short on time, so we'll hold questions now till the end so that I can make sure.
This is just really quick. I just want you to, these are, so businesses, do you have employees that need to be paid? Does a business need to be sold or wound down? Are taxes being filed? Like, do you have valuables that need to be secured? Right? Do you have a Picasso in your house? Should we get 2 locks now on the door? Jewelry, watches, those should be, let's make sure that we're making sure everything is safe. Keep a list of your children, your grandchildren, their addresses, emails, phone numbers. These things change, but you can keep a list of them. I may not know who all of your grandchildren are. You might not have all of your grandchildren when you come to see me. You may get one. Your children may be proliferating. Are they your friends? So how do we get in touch with them? We can probably find them if you give us just any information about them now, or if you have it on your list, if they move. So these are handouts that we'll give to you, but this is sort of the initial whammy before you start doing things. Just these are sort of like little things you can do when someone. This is a page from our, a list that I give people to fill out for themselves. I don't need it, but it lists who are your children, who are your grandchildren, where should I go to the bank? Should I do that? Do I have a business? It just is a list, essentially. It doesn't need to be on this form. Your attorney might have a form. You can use the little notepad that the real estate agent mails you. It does not matter. Just maybe keep a list. Help people, help them. Okay. All right. Not really. Okay. What do we got?
Oh, sorry. Hang on. We got questions. Okay. So if there is a bank account with a beneficiary, but the trust says a different beneficiary, which one do they follow?
They will follow the beneficiary you have listed at the financial institution. A beneficiary designation trumps any other document you have.
Okay.
It is not. So yeah. Okay. Go on.
Can you clarify, is a POD placed on the bank account or on the payee account?
I don't know what they mean by payee account, but it's on the bank account. So if I have like my checking account at Wells Fargo, I get my direct deposit in there, I pay for Hulu from there. I can list my trust or my daughter as the pay on death beneficiary on that account. So it ends in 9150. I go to Wells Fargo and I say, I need account number 9150 to be put into, to have a beneficiary designation.
Do you recommend having everything on auto pay?
That's going to be up to you. I mean, I personally like it for myself just because it takes, there's a little bit of a getting used to it type of feeling, but just knowing that I don't have to do anything and my life insurance premium gets paid, my everything gets, I don't have to do anything. The less I can do, the happier I am. But it'll depend because there are certain things you can't put on auto pay. Sometimes like the gardener maybe wants to get paid in cash or something. You might have automatic things coming in. But yeah, it does help. And a lot of times people's children will help them set that up for them if they want to do that.
And then this person says, I've heard that a trust can help prevent assets being seized in a Medicare look back. Maybe they mean Medicaid. And do you have any thoughts on that?
So in, I believe 2017, but maybe I'm wrong on that, so don't quote me. The state of California, they confirmed that assets in a revocable living trust were not subject to Department of Healthcare Services attachments. So that means if when you pass away, if you have received Medi-Cal, you are potentially, your estate is potentially liable to repay what you received. Your trust is not considered part of your estate, therefore they do not have access to those assets. Again, you want to talk to an attorney to confirm that. I actually practice not so much in public benefits or Medi-Cal or sort of that sort of asset protection planning. I don't really practice in that area. I do have attorneys that I refer to for that are just phenomenal in that area.
Thank you so much.
Yeah, anyone else?
Is it over with or?
Well, our time is coming to a close. So there was also a question online about if we have referrals for attorneys. And so Senior Concerns offers a program called Legal Concerns. So if you have a question, if you want to know, do I need a trust? We have estate planners that volunteer their time to provide free consultation appointments. And so you can call us and sign up for one of those. It's a consultation. They're not going to create a trust for you, but they can answer questions about it because, you know, as you're hearing, some of this really is specific to what your needs are. So yes, I do have a list of those attorneys as well as we have Heather's information available for you. The handouts we have here for those of you in person, I will hand those out, but I will email them to everybody who logged in online. We also have been recording this and I will email that out and it will be posted on our website. So if you want to watch this again or send it to someone that you care about and have them watch it, that will be available to you as well. Any final thoughts? Jump in there.
I think it was terrific.
Oh, thanks.
Yeah.
Here we go. This is what we do with that.
Happy to, if anyone else has any questions, I don't think.
Thank you so much. At home, we can answer this morning.
Thank you all.
I've gone through all